All rise. Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here this morning in State of Arizona versus Lino Alberto Chavez. Our number is CACR 150482. These proceedings are being audio and video recorded, so we would ask that when you approach the podium for the first time that you state your name and who you're representing. We have conferenced this matter. We're, I think, familiar with the basics, but we look forward to your argument. And with that, counsel, you may begin.
Your Honor, I would request to be able to reserve 3 minutes for rebuttal for either myself or co-counsel to use, if appropriate. May it please this court, my name is Janelle McCann. I am the court-appointed counsel on behalf of Lino Chavez, who is the defendant here. I am joined today. I will be handling basically the practical implications of this matter as it relates to Mr. Chavez's case personally. With me is my co-counsel, Mr. Keith Hilsendegger of the Federal Public Defender, and he will be up later to speak about the global implications of this case to other Arizona cases similarly situated.
Counsel, before you get into your argument, I'd like to ask you a real basic question. That is,
yes.
Is it your position that there is sufficient Arizona Supreme Court case law that mandates that Anders review not be done in these cases?
Your Honor, no, it isn't. No, it is not. The fact is that there is no actual Arizona case law that I have found that specifically deals with the situation that we're presenting here, which is a defendant who at a very late stretch in the case has asked this court to perform an Anders-type review. So that what Mr. Chavez has done is actually point up a flaw in Arizona's PCR schema, and we need to, that's what we're going to be asking the court to do, is hopefully to attempt to work with that flaw and resolve it.
Didn't Smith specifically say that we are not supposed to do Anders review? We being the Court of Appeals.
Your Honor, my understanding of that is that that was for types of cases. Again, we have two types of cases, two tracks, two avenues that we pursue in Arizona, which is one, there's a trial track. Defendants who go to trial have a direct appeal. They can raise their Anders issues in an Anders brief on direct appeal, then go to PCR. We now have also pleading as of right defendants who do not have any other type of review other than a PCR.
Didn't Smith involve a pleading defendant?
No, Your Honor, or it may have involved a pleading defendant, but we're talking about a situation where it's in this stage here where he's asked this court. What I'm going to be asking for is not for actually this court to perform the review. In the end, what I'm going to be asking for is for the trial court to perform the review, because there's also an issue in Mr. Chavez's own pleadings that needs to be resolved below by the trial court that was not.
Well, let me give you, I'm reading now from Wilson versus Ellis. It's a 1993 Arizona Supreme Court case. And in Wilson, they specifically say, we are not commanding, nor do we want, trial courts to conduct Anders-type review in PCRs.
Your Honor, they're saying that. However, what we are urging the court to do now is because those old cases, a lot of those cases are coming from a time when, beginning in the 80s and 90s, when pleading as of right defendants were starting to be bifurcated off and given only one avenue of review, which is a review of their case through the post-conviction relief process. And they don't have any ability, any mechanism open for them to request any type of prophylactic review of their cases.
But shouldn't cases that are decided by the Arizona Supreme Court after 1992, at least involving cases that post-state 1992, shouldn't they be dispositive in terms of our review?
Your Honor, we're not believing so because, again, with the case laws, what we're saying is that those case laws have allowed a fundamental flaw in the case in that pleading as of right defendants, such as Mr. Chavez, do not get any type of prophylactic, either arguable issue, colorable claim, fundamental error type review in their cases.
Okay, but you're not asking us to conduct
No.
that type of review. You're just saying the Superior Court is obligated to
The
conduct that type of
Superior
review.
Court should be obligated to do that, yes.
On a sua sponte basis, is the way I read your pleadings.
Well, either on a sua sponte basis or upon asking, and I believe that there is now with a task force that is coming up that is starting to try to work on the Rule 32 schema and require a little bit more substantive.
But in this
elements.
case, there was not a request, so you would be asking us to rule that there's a sua sponte obligation?
What I would be asking the court, what my final pitch to the court is going to be, is that the court remand this matter to the trial court based on the fact that there was no discussion of at least one of Mr. Chavez's issues, which is the issue of ineffective assistance on the plea negotiations. Normally, a trial court would hold an evidentiary hearing on that anyway. And that request that I, as his counsel, would do basically the Chavez brief type workup that was called for in co-counsel's brief, set forth the facts of the case, set forth issues that I've looked at and decided whether I believe they're arguable or not, set forth Mr. Chavez's claims, and then have that issue requested properly before the trial court. Then the trial court, along with an evidentiary hearing on the plea negotiations and the effective advice during plea for Mr. Chavez, could also then perform a review of whether there exists any other type of error, and again, using the list of examples that was provided in co-counsel's
But are you
brief.
suggesting there's an evidentiary hearing in every case?
They're not in every case. Again, if we could get this as a habit to where counsel, instead of just filing the basic Montgomery notice where they just say, I reviewed the record, I find no issues, I'm asking for time for the defendant to file their own brief, where counsel is actually obligated to go through and do a discussion of their issues or of what they've looked at in the case, the facts and procedural posture of the case, and then formally request the trial court, then yes, then we might be able to avoid evidentiary hearings.
But how? Go ahead.
Based on what you just said, but that's different. I read your briefing as saying that the lawyer in this case complied with current Arizona law in filing her Montgomery notice.
Yes, technically she did. We have a case that has some flaws here. Counsel didn't file an Anders type request. There is no mechanism right now for her to do so. The trial court missed this issue of effective assistance in plea negotiations and summarily dismissed Mr. Chavez's appeal. So now it's going to have to be up to this court to remand the case back to the trial court, not only for an evidentiary hearing on that issue, but also for a complete workup by me as his counsel to go through and scope the case for error, write a memorandum indicating what issues I've looked at, what materials and things that I've looked at, and then request the court basically to perform a prophylactic review. And
I'm a little puzzled by what a prophylactic review would look like, where you have, if you file something that says, I haven't seen anything relating to ineffective assistance of counsel that's arguable, what would a superior court do with that? The court presumably isn't going to hire an investigator or do something to investigate claims of ineffective assistance.
No, they wouldn't do something. They wouldn't do something along that nature. But again, just basically.
What would they do other than look and see if there was a proper colloquy? Somebody has pled guilty, so they've waived all constitutional claims. So
Right.
What is there to look at other than the colloquy that the court went through in accepting the plea and whether the sentence is within the range?
Basically, again, was the defendant charged properly? Was there the arraignment? Was the defendant properly advised?
Hasn't he waived all that by entering a plea?
You know what? If he had saved all that by entering a plea, there would be no need for a colloquy. What we're ultimately asking for,
The colloquy go to the voluntariness of the plea?
the colloquy also makes sure that he's properly advised, he understands his rights, his ranges of sentences, and the fact that he's giving up certain rights to trial and to have certain issues raised on his behalf. And there again, I'm seeing I only have almost 45 seconds, so I'll save that for review, and then if Mr. Helzendecker would like to address you next.
Good morning, Your Honors. May it please the Court. My name is Keith Hilzendegger, and I'm here on behalf of the defendants amici, the Arizona Attorneys for Criminal Justice, the Pima County Public Defender, and the Federal Public Defender for the District of Arizona.
Counsel, I'd like to start off with the same question I asked your co-counsel, and that is, aren't we bound by Arizona Supreme Court opinions that say there's no right to Anders review by the trial court?
So I agree with you, Your Honor, that there are specifically statements in Wilson versus Ellis and State versus Smith that do seem to directly command that Superior Court judges are not supposed to conduct an independent review of the record commanded by Penson versus Ohio. I think those cases have been implicitly overruled by the U.S. Supreme Court's 2005 decision in Halbert versus Michigan. Because in Halbert, the Supreme Court said that
And whether I agree with you or not, isn't it the prerogative of the Arizona Supreme Court to tell us that some other case has overruled their case, and not us to tell the Supreme Court, oh, by the way, your case has been overruled, so we're no longer
I
going to
think
follow
that
it?
this court is bound by the Supremacy Clause to follow the United States Supreme Court, especially when there's intervening precedent. And in support of that assertion, this court can look to Division II's decision in State versus Nottingham, where the defendant had requested a Desero hearing, and aspects of what the defendant had requested were affected by the U.S. Supreme Court's intervening decision in Perry versus New Hampshire. Division II said that, well, now that we have state precedent and we have this intervening precedent from the U.S. Supreme Court, we have to, just on our own, adapt the state precedent to what the U.S. Supreme Court has subsequently said.
And are you suggesting that Halbert versus Michigan suggests an obligation on the part of this court to conduct an Anders-type review, or the Superior Court, both?
Your Honor, I'm saying that Halbert clarifies that it is the obligation of the Superior Court judge, the judge that conducts the first-tier direct review, to, when confronted with a request to withdraw.
Halbert said that if you're going to have a Rule 32, the equivalent of a post-conviction relief proceeding, that you have to appoint a lawyer to represent them.
Yes, and by extension,
In that case about Superior Court review, did they?
by extending Halbert and the requirements of Penson versus Ohio, which dictate the Penson versus Ohio and also Smith versus Robbins, which also post-dates the Arizona Supreme Court's decisions, Penson and Robbins dictate the prophylactic measures that the court, confronted with a request to withdraw, has to go through to ensure that the defendant's right to counsel in the first-tier direct review is entitled to. Halbert clarifies that it's the function of the proceeding rather than the label applied to it by state law that determines whether this right to counsel applies. And I think it's clear that both the state, the amici, and the defense all agree that a defendant has a federal constitutional right to counsel in an of-right post-conviction proceeding, because that is the mechanism provided by state law for affording that defendant his first-tier direct review.
What are you suggesting that review would look like in the Superior Court? What types of issues would the court be looking at on its own?
So I included in my amicus brief a list of issues that the court should ensure that defense counsel has reviewed. And so there are situations where, I agree with Your Honor when you said that it's limited to, the basic function of the review is to ensure that the plea is voluntary and that the sentence is lawful. But in ensuring that the plea is voluntary, the defense counsel and the court have to ensure that there are no issues relating to ineffective assistance of counsel in connection with either plea bargaining or.
How would they do?
So I understand that. I understand that's the practical concern here. How they would do that is the judge's role in this process is to ensure that defense counsel has satisfied her obligation to communicate with the defendant and either determine that he doesn't want to raise these kinds of IAC claims, or that the defendant understands that he, in fact, did get correct advice about what pleading guilty would mean.
Isn't that what we do, though, in accepting the plea? Isn't that kind of essentially the defendant has agreed to plead guilty. The court's not going to accept it unless it goes through a colloquy that sort of functions as the type of review that you get in a case where you've gone to trial. The court doesn't accept that unless it goes through this colloquy.
So, first of all, the requirements of Rule 17, is it, that set out the requirements of the colloquy? It's not 17. Whatever the rule is, there's a rule that says what the judge has to advise the defendant of and then make sure that he understands. But none of those advisements relate to what did your lawyer tell you about accepting this plea? What did your lawyer tell you about what would happen if you go to trial?
Wait a minute. You're saying the judge should ask the defendant about the advice he got from counsel?
I'm not saying that the judge should ask him that during the plea colloquy. I'm saying that the function of the function of the upright Rule 32 proceeding is to make sure that someone has explored whether he got the right advice, whether someone told him, look, like Mr. Chavez, for instance, he could have taken his chances at trial and perhaps been convicted of a lesser included offense of the predicate felony that would have taken away the murder charge. Someone should have advised him, perhaps, look, this is what the likelihood of going to trial in this case would mean. You have a small chance.
Why shouldn't we make that part of the initial colloquy then? Why have it be a separate appellate right? If you're saying it's kind of a fundamental part of the process, shouldn't it be part of the initial colloquy rather than why do we want to create another layer? If you're saying that's going to be the case, every defendant has that right, why not have that just be part of the initial colloquy?
As a practical matter, maybe that should happen, Your Honor. Maybe there should be a requirement that some type of Donald hearing happen in every case. Outside the procedural context of this appeal, I think that question is sort of outside the universe of the issues that are before this court to decide.
But so we have a case where there's a pleading defendant, pleas accepted, file this Montgomery notice, and the attorney says there may be something I'd like the court to look into ineffective assistance of counsel. What do you contemplate the court would then do? The
court would then issue a directive to the lawyer appointed to the upright post-conviction proceeding to communicate with the defendant and, without necessarily revealing privileged communications, explain to the court what they did to review the offer that was made, the advice that was given about this offer, the advice about his chances at trial, and then file some sort of notice, explaining what happened, so that the court can satisfy itself that the defendant's right to counsel in this proceeding has been satisfied. And if that review turns up a potential claim, as there may be in this record, then counsel doesn't file this sort of abbreviated explanation and then I don't find a claim for relief. Counsel files a Rule 32 petition, and it proceeds along that track, deciding whether the claim is colorable, and if it is colorable, then setting an evidentiary hearing after, of course, receiving a response from the state. I see that there's a couple of minutes left, and I'd like to save those for our side for rebuttal, if I may.
Sure. Counsel.
May it please the court, counsel. I'm Robert Prather on behalf of the state. The court already addressed the two, what we think are the insurmountable obstacles in deciding this case, and that the petitioner waived this claim. Anyway about it, the issue's been waived. It cannot be addressed.
But are you saying you can waive the right if there's an obligation on the Superior Court to sua sponte conduct this type of review?
Well, there is no, that's the other insurmountable obstacle. There is no duty on the Superior Court to sua sponte.
But aren't they suggesting that, for example, this court has a sua sponte obligation to to do, I guess it's not a sua sponte, but we have to review for fundamental error, we have to review for error in an Anders case.
And in that case, the petitioner would be asking this court to perform the duties of the superior court and to step in the shoes of the superior court. It's not.
Well, but they're not
addressing an
asking
issue
us to
on
do
a-
the review. They're just saying the superior court had a sua sponte obligation to do this type of review.
I don't believe the court does. There's nothing, they can't cite anything that shows that the court has that duty to sua sponte, perform that review. If you look at the case where all this originated, the Pachenko case, he specifically asked for fundamental error review in that instance. So it's distinguishes it from this case where the petitioner didn't even.
Pacheco would have been different. There would have been a different ruling in Pacheco had the defendant not asked for the review.
Well, that was decided under habeas procedure, so it depends on how that was raised at the habeas proceedings. But I think the fact that it was specifically mentioned distinguishes it from this case. And I think that creates an obstacle here that this court simply just, there's nothing, no error to correct, and this court has no authority to send the case back.
Assuming the procedural hurdles are overcome, do you believe that there is a constitutional obligation upon the Superior Court to review Rule 32 petitions for arguable issues under Anders?
Well, as the state mentioned in its brief, and as the Attorney General's amicus brief mentioned, that the state does believe that they have a right to what's called an Anders review at that time.
So the court would have an obligation to sua sponte review the.
Well, under Anders, it's the attorney should submit something to the court, and the court should and request the court to perform such a review. The court at that time, the review really focuses on what counsel did rather than the case at whole. They're just double checking to make sure counsel didn't miss an issue. They're not stepping into a role as an advocate for the petitioner or the.
But the court's going through kind of a checklist. The court reviews voir dire proceedings, views trial proceedings, rulings on motions, a host of things that are taken off the table, it seems, by a guilty plea if you've waived all constitutional claims. So it seems like it would be a very different type of review, and I'm still a little bit puzzled as to what the extent of that review is.
Well, that was the state's other issue I wanted to present to the court is under Smith v. Robbins, the states have significant leeways to craft whatever review they would like to craft. The court made clear that it mentioned the states are the laboratory to experiment with this sort of thing. Also, that if you look at what the petitioner's requesting, what amicus advocates, if you try to overlay that on this particular case, it's going to be very difficult because what you have, the court will look at the record, which exists of the entering the indictment, the plea, the sentencing transcript, other pleadings. That's all it has in front of it. Amicus counsel mentioned an expanded record.
Isn't that what, in 90-some-odd% of all of the cases that we have in Superior Court, that's what we would have in a Rule 32 proceeding overall?
Anecdotally, I would agree with that it's mostly on upright proceedings that would be the case.
I'm really having trouble understanding how that makes any sense whatsoever. You have the Superior Court go through a basic criminal procedure. We tell them they have to apply the rules. They have to, if they're going to conduct a plea acceptance, they have to follow the colloquy that's prescribed. And now we're going to say they sua sponte have to just have a redo potentially in every single case?
Well,
what is the point of that? Why not do it 3 times or 4 times? What is the efficacy of having the same court redo what they just did?
Well, the state generally agrees with that proposition because, essentially this boils down to
Here in this case, let's be frank. You said in your brief that the court was obligated to do that.
We believe that the Anders procedure should be
Oh, well, if you believe
imposed.
the Anders procedure should apply, then you would say, yes, we think they are obligated to do a sua sponte review in every single one of those cases, which then goes to Judge Thompson's point. Why would we do that?
Well, the question is the quality of counsel's advice to the client regarding the
But
acceptance of the
isn't
guilty
that part
plea.
of the colloquy and accepting the plea? And Judge Thompson's point, this is fundamentally different than Anders, where you're asking another court to do a review, but here you're just asking the exact same court that's accepted the plea to basically go back through the same colloquy, or apparently an expanded analysis of the same colloquy.
Well, at this time, the court will be looking at post-conviction counsel's actions and whether post-conviction counsel drew a correct conclusion and that there's only frivolous claims to be presented. The court will look at counsel's...
But what issues are there other than issues that go to that colloquy?
I believe in the amicus brief of defendant, they listed a number of potential claims that could be raised or that could be addressed at that juncture. So there are some where there's a practical matter.
Aren't those, I mean, the ones that are of record, meaning they are part of the trial court record, are exactly what Judge Thompson was talking about. We have a judge who has followed the bench book. We have a form plea agreement that they're all using throughout Division I, where the defendants initial the box that waives all of their constitutional rights. What are we asking them to look for? Everything that is discussed is outside the record.
I agree. If you look at the report and recommendation on the Pachenko case, the magistrate judge there indicated that post-conviction counsel will be looking at a little bit larger of a record. They're going to be looking at police reports. They're going to be looking at correspondence with counsel and client, and look at disclosures by the states, among other things.
Well, why would that principle not also apply in non-of-right PCRs, since the PCR is the first opportunity to raise ineffective assistance of counsel? Are you saying there's an obligation in every PCR? Here we're just talking about pleading defendants. I assume you've limited your discussion to of-right defendants, but doesn't that same rationale apply to every defendant who's gone through trial? They can't raise ineffective assistance on direct appeal, so they raise it in their first PCR. So there's presumably then, why isn't there an obligation then on the part of the Superior Court judge to conduct this independent Anders-type review in every single PCR?
Well, ultimately, Anders and all those cases focused on the right to counsel and effective counsel on what would be considered an appeal. The other post-conviction type of proceedings aren't technically or
but
categorized
Anders
as an
limits the
appeal.
court's review to the record before it. And reviewing a claim of ineffective assistance of counsel that has not been raised, it's fundamentally different. You can raise, in some states, maybe you could raise ineffective assistance before the direct appeal, and you litigate it, and there's a record, the court could look at it. And that might be an appropriate thing to look at. It's part of the record in front of the court. But if you have a scenario where the issue has not been raised, defense counsel has looked at it on appeal, meaning a PCR after a trial, defense counsel looks and says, I can't find any ineffective assistance of counsel, or I don't find a colorable claim. What possible type of review is left for the Superior Court in that case? There's been a trial. There could have been all kinds of ineffective assistance in terms of witnesses to be called. But how would the court be in a position to undertake any type of independent review of ineffective assistance of counsel?
Well, in that case, a criminal defendant has other avenues of relief, namely they file a habeas petition where they raise those issues.
They have that in this case.
They can only raise in the habeas petition those claims that they raised in state court. But going back to the discussion, is in a Rule 32 of right, if we say, if somebody files a Montgomery notice and they list all of the things they've done, they've reviewed the police reports, they've spoken with the defendant, they've done all of those things. What is that then? That all of that information has to be provided to the trial court so that he or she could file it, do an independent review of all of the other things?
Well,
Isn't that the only way that they could review those determinations to determine whether there was an arguable issue under Anders?
Well, if you look at Smith v. Robbins, the court only required that the so-called Anders counsel provide a factual and procedural history, just something that can confirm or assure the court that the defendant did have a meaningful appellate review, had a learned eyes of an appellate attorney look at his case and draw a decision.
But once that's been done, it's still, there's another step where you're suggesting the court needs to do something with it. And what does the court do when it would necessarily have to do its own investigation to decide whether those claims are meritorious?
Well, that's not too much different than what the court would do now on a pro se defendant who raises an issue of ineffective assistance of counsel, and PCR counsel has filed a notice of compliance and that there's no issues. The court can still review that and say the records may be silent on.
Well, but presumably the pro se defendant has provided some facts that the court would then consider. But if you just have a defense counsel who says, I can't find anything, what is there for the court to review?
The court there is to review that counsel provided the meaningful review of the case from an appellate perspective, see if there was any glaring or issues that appear arguable that should be addressed. If not, the court then can summarily dismiss the case.
Well, again, it goes to, in that scenario that you just described, we're relying on the defendant to present the information, right?
Well, if we have so-called the Anders review, or the PCR counsel provides the court with the assurances that it reviewed the case, a factual and procedural history, maybe an affidavit of itself saying it attested, it reviewed the entire file, finds no issues, the appeal or the post-conviction proceeding will be frivolous, they'll have that information.
Well, what does the trial court review then? If Anders was supposed to be a check on what the lawyer had done to determine whether or not this was a non-frivolous appeal, right?
Right.
Okay. In order for that to happen, the appellate court reviews the same record that the lawyer reviewed and determines whether there's anything in that record that would give rise to an arguable issue, meaning that the appeal is not non-frivolous. I know there's a double negative in there. But in this scenario, the one we're describing, unless the defense attorney is giving all of that record to the court to say, here, you review it. Here's the police reports. Here's all of the other things that I've looked at. The trial court's record consists of the change of plea colloquy and the sentencing for most part. So what is it he or she supposed to be reviewing to determine whether there's an arguable issue on the non-record based claims?
Well, there's the step where you're missing is that counsel, if they file this Anders type brief or Chavez brief as it's called, saying there's no non-frivolous issue, they have to then go to their client and say, here's what I've filed, here's what I determined. You now have a right to bring any issue you'd like to the court yourself.
Don't they have that right now with
Right. Yes,
Montgomery? Sir. Isn't that contemplated? A defendant can file his own pro per petition?
Yes, sir, but I'm trying to indicate that by filing that pro se or pro per petition, the court then has something else or another issue that it could, direction that it might want to examine or determine that.
A petition for review. So this is the defense.
I'm sorry, I meant the petition for post-conviction relief.
And that's what happened in this case. What you've just described happened in this case. Mr. Chavez filed his own pro se petition. Mm-hmm. The trial court addressed all of the issues raised in the pro se petition, determined they were not colorable, and dismissed them.
Correct. Yes, I think that's an important point in this particular case, is that the court did a thorough review of the issues that it was asked to review and provided a very comprehensive decision and what it looked at and how it came to its decision. So the court here, the post-conviction court, did everything it was asked to do, did everything that it's supposed to do at that time. And
so if we send this back, what are we to tell the Superior Court to do?
that's the state's position, is that there's nothing you can tell it to do. I mean, it did everything it was supposed to do. There's no error to correct. If there's no further questions, that's all of the state.
Could I start with my question on why would this theory not also, argument not also apply to non-pleading defendants who are raising ineffective assistance for the first time in their first PCR?
Why would it not apply?
Are you suggesting there should be an Anders-type review in every PCR, regardless whether it's a pleading defendant?
I haven't made that suggestion, Your Honor, because...
And I'm just wondering why the logic wouldn't dictate
I'm going to do that lawyer thing where I say that's not this case, but then I'm going to explain right after that. It's not this case because this defendant pleaded guilty. The reason I haven't made that argument is because under Martinez versus Ryan, there's no federal constitutional right to counsel in a true collateral review proceeding where the defendant has gone to trial, he's been convicted, he's had a direct appeal. His federal constitutional right to counsel ends there. As a practical matter, because...
Wait, hold on. I thought Martinez versus Ryan said he was entitled to effective assistance of counsel in raising claims of trial ineffectiveness.
So the distinction, distinction is very fine, Your Honor. There is not a Sixth Amendment right to counsel. Instead, the Sixth Amendment standards apply if the defendant brings to federal court for the first time a claim that he didn't raise in state court because, as what happened in Martinez, counsel filed a notice of completion, it didn't raise any claims. The Strickland standard applies there to excuse the failure to present the claim to the state court. That's a technical distinction that's for federal court. If this court wants to treat Martinez, and maybe it doesn't have to say this at all, but if this court wants to treat Martinez as imparting a Sixth Amendment right to counsel in post-conviction proceedings where defendants went to trial, that, I suppose, is something the court could do as a matter of state law. But getting back to the procedural posture of this case, as a consequence of the fact that 25 years ago, the legislature took away the right to a direct appeal and instead made this proceeding, this hybrid direct collateral review proceeding, it's our position that because there's at least some part of direct review that goes on here, the Anders review has to apply to all of it.
Okay, well, let's go with that for a minute. Let's assume for the sake of argument that there was not, we were back pre-1992 when there were direct appeals from plea agreements. The record would simply be, on direct appeal, the bare record, the change of plea colloquy, and the sentencing transcripts.
That's correct.
And so it goes back to what we've been asking now for the last, 30 minutes. What is there in that bare record that we could possibly look for arguable issues?
There are defects in the plea colloquy. Did the judge tell the defendant, for instance, that he had a right to a jury trial on the aggravating factors?
In the form, in the plea agreement?
I don't know that answer off the top of my head, Your Honor.
It's a standard form in the criminal procedure. All of the Boykin rights are in the plea agreement themselves. And the standard is whether or not he knows from the colloquy or any other source. So as long as he's, initialed the box and signed the plea, is that an arguable issue? I mean, we're in trying to determine what arguable issue we could direct the trial courts to look for on a bare Anders review. What is it they could possibly find?
There arise defects in the plea colloquy. Apart from it's not just maybe this is sort of implicit in what I'm trying to say. It's not just the obligation of the prosecutor and the defense to get together in a secret room and have the guy check some boxes on a form, and that satisfies the obligation for the judge to determine that his waivers are knowing and intelligent. The judge also has to conduct a colloquy on the record to make sure that the stuff he signed, he understood it. And sometimes, not often, there is a concern that there would be endless repetition of all these cases in a large number of cases. I don't think that's true. I think
every time a defendant asked for Anders' review, it would have to happen, or it would have to happen sua sponte, according to your theory.
Well-
Which would mean every single time when we tell a Superior Court judge, if you're going to take a plea, you have to follow the colloquy, so we expect that he's going to do that. But then we're going to say, and then if there's a Rule 32, you have to go over it again and make sure you did it right. Well, how many times does he have to make sure he did it right?
Once.
I mean, and if there were a defect in the colloquy, isn't that the sort of thing that a lawyer looking at is going to say, oh, there's a defect in the colloquy?
Hopefully, but if the lawyer overlooks it, as happens from time to time, he has a right to counsel in this proceeding, and the purpose of the independent review is to ensure that that right to counsel was honored. And if it's arguable that, hey, wait a minute, they didn't tell the defendant, for instance, that the prosecution has to prove its case beyond a reasonable doubt or something, is that something that should require the plea to be set aside? And then, of course, once that issue is flagged and it gets briefed, then the court can decide, is it harmless error? And frequently it will be harmless error.
But we're still talking about issues that are different than ineffective assistance in advising regarding the plea.
Because I thought that was the premises of the questions that I was getting.
But
Okay.
would it, I guess, if we looked at this as if we had not taken away the right to an appeal, the only issue that would really be on the table is you've waived everything, waived constitutional rights other than the voluntariness of the plea. Would it make sense to say, court, the Superior Court was supposed to go through that, but somebody needs to review that. It seems odd that we're going to have the same judge review what he or she did, but assume we assigned it to someone else or had a different kind of review. Would it make sense to say, well, that review is limited to the record that would be there if we gave you a direct appeal?
It would be consistent with the requirements of the 14th Amendment to limit that review to what is traditionally considered direct review. So in the pre-1992 context where you were allowed to file a notice of appeal, incidentally, what happens in federal court is you're still allowed to file a notice of appeal even if you plead guilty, and that review is basically confined to a review of the adequacy of the plea colloquy and sentencing issues, with IAC issues diverted to a post-conviction proceeding. In that situation, I guess it would be consistent with the 14th Amendment to limit the independent review prophylactic stuff to that aspect of the record. The problem is that's not what this proceeding is. Arizona made a choice under the laboratory of democracy theory. Arizona made a choice that this is the kind of direct review we're going to provide. And it happens to be a Rule 32 proceeding, which normally is post-conviction, but now gets pressed into service to do this too. And our position is, if that's the structure that Arizona is going to provide, the Andrews requirements have to apply to all of it, if only to prevent a federal court from later on from setting aside the default and granting relief. And if there are no further questions from the court, I'll ask the court to vacate and remand.
Thank you. Thank all of you for your argument. We will take this matter under advisement and issue a decision in due course. That we're adjourned.